Sometimes the parties to a divorce cannot reach an agreement and must proceed to trial. Though the benefits of settlement are numerous, you cannot simply settle for the sake of settling. A marriage involves two people who have devoted their finances, time, emotions, and energy to jointly build a family and assets. If a spouse refuses to treat the other fairly and equitably through negotiations, fails to recognize that each of you should receive an equitable portion of the assets, regardless of who was the primary breadwinner, you may want to take your chances with a trial. Likewise, if the final offer from the other side is less than what you would likely receive at trial, you may want to take your chances with a trial. Sometimes, the parties are so incredibly far apart on what they believe is in the best interest of the children, or what they consider as fair and equitable, that the only option is to let a judge decide. Settlements necessarily involve compromise. Settlements do not require you to give up or give in and walk away. Don't feel pressure to compromise to an extreme. Discuss the realities of your case with your lawyer and determine your best options. If you have a good chance of winning and getting more from the judge than you would through settlement, it may be necessary to go to trial. It may be necessary to go to trial if a spouse has committed egregious behavior, such as domestic violence. It can be cathartic for the innocent spouse to have a judge hear their story and determine the outcome. This can start the healing process and closing the door on a painful ordeal. Victims sometimes need to be heard, and telling a judge about the egregious behavior can initiate the healing process for a victim. If you're facing divorce or other family law matters such as child support, child custody, adoption, or more, we want to help.
New life, new directions, new beginnings.